Florida guardianship lawsuits and the right to marry. Hello, my name is John P.L.L.C. I'm a probate litigator with the Florida law firm, the P.L.L.C. law firm in West Palm Beach. We handle probate litigation, guardianship litigation, and related business lawsuits and appeals. Today is April 26, 2016, and I'm going to be speaking to you about the Smith case. The Smith case is a guardianship appeal affirming Judge David French's ruling in a guardianship matter involving the right to marry that was affirmed by the 4th District Court of Appeal. The 4th District Court of Appeal, or 4th DCA, hears guardianship appeals for Broward County, Palm Beach County, and Martin County. So this case is the Smith case, S-M-I-T-H. It was issued March 2nd, 2016 by the 4th DCA in Florida. And if you're a Florida guardianship lawyer or you're a family member who's involved with an aging or a fragile adult who may need protection or who may be the subject of a guardianship matter, and you're wondering about the right to marry, you may want to read the Smith case. The Westlaw site is 2016 WL 803625. The appellate case number is 4D, 4th District 14, filed in 2014-1436. So what we had in the Smith case, we had a gentleman who was declared to be incapacitated or incompetent, and court-appointed counsel was appointed to represent him, and rights were taken away from the ward. In Florida and in Florida guardianship matters, if somebody is found to be incapacitated or incompetent or in need of assistance, a probate court judge will determine what rights should be removed from a ward and what rights a person may retain. So Florida guardianship litigation seems to be exploding. I know our firm has been involved in guardianship matters much more than we were 10 years ago, and now it's a very important part of our probate law practice in West Palm Beach. So what happened was a gentleman was declared to be incompetent, and the court removed his right to marry. So in Delray Beach Probate Court on Atlantic Ave, Judge David French removed the right to marry for that ward. Very common in the guardianship setting. What happened? Judge David French's probate order said that, you know, if you want to marry, you got to come back to the court, right? That marriage was subject to court approval. Very characteristic, very common, very typical. The gentleman who's the ward went out and got married without court approval. And so the court-appointed counsel filed a guardianship motion or petition with the probate court in Delray Beach to annul the marriage and was successful. And on appeal, the 4th DCA said that Judge French's order was correct, his interpretation of the statute was correct. Anybody who wants to read about removing the right to marry in a Florida guardianship should read the Guardianship Code, which is Chapter 744 of the Florida statutes. And more specifically, you can read 744.3215. In this, the 4th DCA also mentions how one interprets statutes and including the right to marry. For Florida probate lawyers or Florida guardianship lawyers, this is an important case. For family members who are out there who have a mother or a father, an aunt or an uncle who may need some protection or some court supervision, understand that guardianship matters are taken very, very seriously by Florida courts. We're talking about removing or limiting someone's civil rights, civil liberties, and human rights. So it's taken very, very seriously. Remember, if you have a Florida estate plan, you may be able to draft around a guardianship, you may be able to anticipate a guardianship, and you may be able to properly avoid a guardianship. My name's John P.L.L.C., and that concludes my remarks about the Smith case regarding Florida guardianship litigation.